why insurance companies are never ever going after manufacturers.
Number one, play the long game. Don't try to win the storm on every claim.
What resources does contractor have in case of unreasonable denial?
Insurance companies started using them as a weapon.
It finally got so bad in Florida that the reinsurance market said to the direct insurers, we're done.
Can they force homeowner to use their contractor?
So you've just impugned the entire AAA, saying every AAA arbitrator is a fraud in favor of insurance companies, and that's just wrong.
Only those that are listed as umpires.
We're noticing the rise of supplement firms, companies who supplement insurance claims. I mean, to me, it seems like every day new player comes in, and average increase of the claim is 30-40% is their claims, claim many agencies. They say the initial increase, average increase is 30-40%. How do you see businesses that specialize in insurance supplements? Do you see them as, accountants who helps insurance companies and contractors just count their estimates, like more like accountable estimators, or do you see them as someone who's abusing overwhelming system already? That's the question. How do you see supplement businesses in insurance?
I can't say that I've seen them that often. However, if they have a system in place that makes it easier for those supplements, I wouldn't disagree using them. Anybody who's helpful in the process, I think Steve would even agree with me on that one. Now, I would pick a path and stick to the path. If you're working with a contractor, let the contractor work. If you've moved on and you're using a PA, let them do it. But I wouldn't utilize both of them at the same time. However, if you do, let them know that. Because I think we all have seen some policyholders that was like, okay, well, I'm going to send these two separate entities working on my behalf off at the same time on the same claim, and we'll just see which one does better. And that's definitely not the way to do it.
So here's what I teach my clients when I speak to insurance companies. If the contractor who has the contract for the roof calls you up after and says, hey, we're done with the job, we had to replace 4 sheets of plywood, 3 turtle vents, and a couple of other things. I've got photos, I'm gonna send you a supplement, you should pay it. Right? Why would that contractor do the work if it was not reasonably necessary? We should pay legitimate supplements from contractors who did the work. But, Dimitri, your question's a little different. Your question is about supplementing companies. These outfits who have shown up in Colorado and other places, who call up the insurance company and pretend they're the contractor. And they say, hey, I'm an Xactimate expert and I'm gonna send you a new Xactimate estimate that jacks up the job from $17,000 to $30,000 with a whole bunch of new line items that were not necessarily done, but they've been to an Xactimate master's class and learned how to supplement and paid $399 to some guy in Topeka teaching them how to do that. And you all know that's what goes on, all right? And what I tell my clients when they get a call from that guy, to hang up on them. You owe them no obligation at all, because that person is trying to make a living off the claims process that they are a stranger to. And you all know they work on a contingency fee. So the more they can bleed out of my clients, the more they make. Now let's go back to the first part of my answer. If a brick and mortar contractor who did the job incurred extra costs that are reasonable and covered, I hope to hell my clients pay for it.
Chad, you have 1 minute you didn't use on this question. So
oh, that's okay. Unless, are there any third-party estimators and supplementers in the house? Or online, just text Dimitri. I have to agree. I mean, unless you're part of the claims handling process for that claim, just stay out of it.
Okay.
I
Thank you
appreciate
for answers.
that.
So we have last question in this segment. And this is from me personally. It's about third party that almost never gets involved in insurance claims. And I want answers why. Why insurance companies are never ever going after manufacturers. So let's imagine, just in the imaginary world, manufacturer comes out and creates warranty claim, unlimited wind warranty, right? And then next thing, wind blows and shingles gets on the ground. Or 130-mile wind warranty and shingles on the ground after 30 miles. Why it's always a claim and never a manufacturer claim? Why we always go after insurance and never go after manufacturer? Because contractors know products, siding, flat roofs, asphalt shingles, they all fail. They're not performing as advertised, but somehow it's always an insurance claim even when it shouldn't, and I never could understand it. Please, Steve, you're smiling.
Wow, this is the best question of the night, and I had no idea it was coming. So the first 20 years of my career, I was a plaintiff's lawyer, working on a contingency fee, but my clients were insurance companies. Once we paid a claim, we had the right to sue whoever was at fault. So for the first 10 years of my career, all I did was sue people who put on crappy roofs. Right? And that's what I learned. I went down to Hurricane Andrew, or Miami after Hurricane Andrew, and I sued a bunch of contractors who put on bad roofs that blew off in the hurricane. I sued engineers who misproperly designed the roofs. My insurance companies would pay the claims, then I would sue them. I sued manufacturers of roofing products whose products failed in reasonably foreseeable hail events. The old PVC products, I settled against a manufacturer for $11 million on a couple of settlements. Just recently, I settled a lawsuit in Colorado. This is all subrogation. Settled a matter in Colorado against the manufacturer of a TPO roof that failed in a moderate hailstorm. So I agree, all right? The manufacturers should not put out a product that they know is going to fail in a reasonably foreseeable hail event or wind event. And I'll tell you, one of the things that's been percolating in my mind that really bothers me, that if I have the energy to do, is I would love to file a class action lawsuit against manufacturers who put out a shingle in Texas that they know will fail in a reasonably foreseeable hailstorm. They shouldn't do that, right? Why should you put out a product that you know is going to fail in a hailstorm that comes along every year and get away with it? So that's something we all have a collective interest in addressing. Or if not a lawsuit, why don't we change our building codes in Texas to only require or only allow Class 4 rated shingles?
Thank you for that. That's probably why deep inside I always liked you. Chad?
So what's not supposed to happen is the policyholder puts in a legitimate claim for hail and wind damage, and it's storm damage, but there's also defective shingles. And the insurance company misrepresents to the insured, hey, your claim's denied, this is defective shingles. And this has happened. Actually, I took it to trial, and it turns out State Farm didn't know anything about subrogation or how that works with defective shingles. But basically, there was one bag of shingles, and they were defective. It was pretty obvious. The roof was about 8.5 years old, and one square that was sporadically put up on the roof had tiger striping to it. Well, the way that it should work is the way that Steve had explained it. You put the insurance claim in, it should have been paid. Obviously, it didn't. We went all the way to trial with it and found out how little State Farm knew about their rights to subrogate against the roofing material manufacturer. And once the claim is filed with the insurance company, the insured doesn't even have the right to go after that warranty. it's owned by the insurance carrier. So even if the policyholder wanted to go after the manufacturer at that time, they can't for that reason. But that's the way it's supposed to work.
Any reply to that?
I welcome the opportunity to work with building owners. When they believe that their roof has failed because of a faulty product, I'd love to work with them in going after the manufacturer under a warranty claim. Let's do it together and go after them. Now, this whole issue of whether insurance companies can deny a claim for faulty workmanship or faulty materials, that raises some thorny coverage questions. I will tell you the thing that comes up all the time that is, there's a lot of confusion. Let's assume we've got an old hardy slate type tile roof and 10 tiles are hit by hail. We all agree those 10 have to be replaced. But when you go up and try to replace that roof and walk around, all the other tiles are coming apart because it's such an old crappy product. All right, just because of that, my client doesn't owe for the whole roof because it can't be repaired because it's defective. All right, we still only owe for the damage to the product itself. We don't owe an entire roof simply because the remainder of the roof is defective. That's the All Saints Catholic Church case from Texas. I'll send it to you. All right, and then that's an area of a lot of confusion. We all should be clear on that.
All right, our next segment is unreasonable denials, excessive demands, insurance fraud. Chad, you're going to be the first answer in this question. What resources does contractor have in case of unreasonable denial or grossly underpaid claim? So insurance comes out, pretty much denies on the spot, or gives very little, obviously not enough. What resources does contractor have or should use in your opinion? Chad?
Power the pin, Dimitri, power the pin. What resources do they have? Well, obviously, most contractors know what should be done, and they can compare that to what the insurance company is actually doing. So when I say the penguins of Madagascar and the smile and wave boys, when they start doing that, write it down. You can take pictures if you want to. When you start taking video, it gets a little bit more combative, and I would suggest not doing that right at first. Now, if it's so egregious that you think that it should be reported to TDI immediately, you can certainly tell the policyholder to do so. And what will happen is the policyholder will put in a grievance with TDI. TDI will turn around and tell the insurance company, hey, you've had a grievance and a complaint against you. You have to respond to it. And the insurance company responds to it at the end. So it doesn't really get you anywhere. However, sometimes it makes the policyholder feel better. I suggest that you make sure that everything's documented, and it could be a text, it could be handwritten notes, a book that you keep in the truck, and say, hey, if you have a conversation, if it's one of those where the IA goes up and they're very agreeable, yes, this, that, blah, 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 send them an email. Hey, we were up on this roof on this claim yesterday. You said if you remember it any differently, please let me know. And that is to combat, as a resource, the denial letter or the underpayment that comes later that isn't anywhere close to the conversation that y'all had at the loss. That's number one. Other than that, unfortunately, it's mostly downstream for guys like me.
Dimitri, your question is wrong. All right? What resources does a contractor have for unreasonable denial? You know what I'm going to say, don't you? All right? The unreasonable denial is to the insured, not the contractor. All right? So the contractor doesn't need any resources. I didn't do anything wrong to the contractor. All right? So the contractor should not be the person going after me. What should happen is if the contractor believes that the insurance company unreasonably denied a claim, then the only thing they should do is tell the homeowner or building owner, hey, in my opinion, this should have been paid. You ought to consult a lawyer or a PA. I got no problem with that. And I know someone who can do it. And as long as then the homeowner calls the lawyer, not the contractor, and the homeowner communicates with the lawyer, I have no problem with that. But what we're seeing is not that. I'm seeing an increase in lawsuits right now down in the valley in a couple of counties down there from the storm that blew through almost a couple of years ago. And it's really interesting. 3 law firms are getting every single matter down there. And we all know what's going on. The contractors are referring all the homeowners to those same lawyers. And in fact, in a lot of situations, which actually caused one lawyer to go to prison for 4 years in hail claims, he was the one signing up the claims with the contractor, not the homeowner. So if you got an insured who you think was underpaid, tell the insured to call a PA or a lawyer and get out of it. That's not your lane.
I'm gonna go with a follow-up question from the audience. Vyacheslav Fish is asking this question, and I agree with it. It kind of goes along with the scenario we just described. Contractors sees the damage, tells homeowner get reinspection. Reinspection occurs, denies again, 3rd reinspection. Claim gets approved. Contractor didn't do anything. He just said, I see the damage, ask for a 2nd, 3rd opinion. So the question is, if the claim was originally denied after their inspection, and after the process the claim is approved and pays, why does it not consider a fraud on behalf of the carrier?
Yeah, so as long as there was a legitimate dispute as to whether or not the claim was owed, that's not fraud. Right? So perhaps they looked at it and they didn't believe, they made a decision. It may have been negligent, it may have been wrong, but if it's not intentional, if it's not an intentional misstatement about the claim, it's not fraud.
What would make it intentional? I mean, it's easy to say intentional.
Hey, oh my goodness, this is damaged, but hey, let's jack with this homeowner because he's blind and not pay it. All right, that would be
at least
fraud.
Cut out the O&P part.
Yeah, so it's, look,
because that'll be funnier.
There is a gray area in the middle where there's lots of disputes. Everyone knows that I've sued a couple of insureds, appraisers, and umpires recently. Got a lot of press. All right, that was not a legitimate disagreement in the middle. That was a gross misrepresentation as to the value of the claim. And I sued them all for fraud. In the thousands of claims that have come through my office in the past 10 years, I've only done that twice. But in my view, that was an intentional misrepresentation. That's fraud. And if my client intentionally misrepresents, they can be sued for fraud. But just because they say, okay, you made a credible argument, we see it, we're going to afford coverage, that's not fraud. Perhaps that's just doing the right thing when there's a disagreement.
And I'm gonna elaborate a little bit. You said you pretty much who showed them, who made the argument? I mean, is it the contractor? Because in your opinion, a contractor cannot even negotiate or show or prove or make argument. As a homeowner, well, homeowner does not know. Homeowner is not an expert. So who makes that argument?
Look, and someone asked me this during a break, where can the contractor go in the negotiation process? And about 6 or 7 years ago, we put a pamphlet together with North Texas Roofing where we all agreed this is the gray area where we can all live. The contractor can explain the damage that they observed and explain the cost of repair. And if that convinces the insurance company to pay, that's great, good. But they can't hijack the claim and start threatening bad faith, et cetera.
All right. Chad, in your opinion, deny, approve, would it make it insurance companies involved first and committed fraud in the first place?
Well, as far as fraud is concerned, I believe insurance companies fraud insureds every day. However, I don't get those claims. I mean, we mentioned it earlier, especially in Texas, we're a very trusting group of people. And as insureds, we put our home or our property, our business, well, our cars, pretty much everything is insured. And we expect the insurance company to do the right thing. Now, if they intentionally or knowingly deny an obvious covered claim and the insured takes it on the chin Well, the part of fraud that we're missing is the detriment, the reliance on that misrepresentation by the insured. So all of those that were wronged and they go by the wayside and they just accept it, yeah, that's fraud because they have accepted it. They didn't rely on it to their, they've relied on it to their detriment. The ones that I represent, the squeaky wheels, the policyholders the insurance company doesn't like, they're the ones who are fighting back. That's the difference.
Next one, I believe Chad is starting. Let's talk about Florida situation. This year, like never before, we see a lot of press about insurance companies going out of business, and their narrative is that it's roofing contractors, door knockers, storm chasers are behind it and pushing them out of business. Your take on it, is it really contractors who contributed and put those insurance companies out of business, or there's other plays behind the scenes that we're not talking about? Chad?
Well, rule number one, always have a scapegoat, right? It can't be their fault, right? It's always got to be somebody else's fault. And when you're pointing the finger at someone, you've always got at least three. For some roofers who've been up on the roofs for a while, it's maybe two pointing back. But I think also in Florida, there was a recent law as far as whether it was lawful for contractors to go and even knock on doors, which, Dimitri, I think we talked about that 250 days ago, as you reminded me, as far as that particular bill turning into law. And I said, well, if what's good for the goose is good for the gander, if you're going to preclude a contractor from going and knocking on doors and warning insureds that they've got possible storm damage, well, then you've got to preclude the vacuum cleaner salesman too. Because it's anyone who's walking up and who's going to sell something. So if these mismanaged insurance companies who basically can't keep their books right, and if you can't make money as an insurance company, you should not be in business, period. I mean, it's pretty ridiculous, especially if you can insure against your own, insure against yourself. So have a scapegoat, and I think the contractors were the easiest prey.
Yeah, the contractors in Florida were not a scapegoat. They were not prey. They were the cause. Because in Florida, Florida allows AOBs. And we all know the problem with an AOB, an assignment of benefits. Once that contractor gets his hand on the claim, all aspects of it, including ownership of litigation, it becomes a profit vehicle. And we all know what's happening with private equity getting involved and everybody coming in and financing litigation now because the insurance claims process has become a profit-driven model. And that in Florida is because of AOBs. We don't have this problem in Texas because we don't allow AOBs. Florida does, and that has driven up the number of lawsuits because they begin with the door knockers, and then the contractors trying to win the storm on every claim, and they know it becomes an annuity. They can dump them all in litigation. The insurance company makes a business decision because they do know how to make money. They make a business decision to settle them, and it just perpetuates itself. And it finally got so bad in Florida that the reinsurance market said to the direct insurers, we're done. Insurance companies buy insurance on their risks. And that's called reinsurance. And the payments got so high that the reinsurers said, screw it, we're done in Florida, and the market was collapsing. And the one reason are those three letters, AOBs. And thank God we don't have them in Texas.
Well, where that argument fails is statistics. And if they were all legitimate claims, then the underwriters in Florida got it wholeheartedly wrong, whether they were AOBs or not. Now,
what statistics, Chad, when you have meritless claims? They sign up every single person, regardless of whether they were in the eye of the storm or not, knowing that they can just sign them up and dump it in litigation. The statistics show that Florida has more lawsuits in weather-related claims than the rest of the country combined.
The last time I looked, an illegitimate claim is still worth 0. So what's the point? I don't know how that affects the statistics.
Because it costs $150,000 to $200,000, as you know, to take a matter to trial. And when they can settle it for 15 or 10, all right, they make a business decision. But in the end, it's costing a ton of money. Those are the statistics.
Are there any actuaries in the house?
I speak to actuaries, and this topic comes up all the time. All right, and there's a big issue about, do we settle these? Do we bundle them up and settle them and perpetuate the problem? Or do we try them all? All right, at 150 grand to try every one, the industry would have been bankrupt 5 years ago and not today. So AOBs, that is the problem.
That's the excuse.
Next question, Chad, you will start. Your position on appraisal process, you can start in Texas, or when do we need appraisals, and do they contribute to the problems or the real solution to the problems in claims process?
Like a lot of things, it started off as a good idea. However, what we've seen, and if anybody's read the book, Who Moved the Cheese, as soon as we on my side, those who dress up in suits, get on top of particular positions or aggressions by the insurance company, they tend to move and change things up. So for appraisals, it sounds great. And you know what? When they first started putting it in insurance policies, it was 2 paragraphs. If you and we disagree, you'll get a person, we'll get a person, they'll come together, they'll get a third, and we'll figure out the amount of loss. However, insurance companies started using them as a weapon. All right, we're going to hold out, we're going to deny, we're going to piecemeal, and at first, we're not going to provide coverage at all. Then a contractor or a PA gets involved, we're going to cover one room to the inside, we're not even going to look at the roof. After they get involved, okay, we're up to maybe $8,000 worth of damage. Lawyer has to sue to get the insurance company's attention. Now, we get litigation costs, and 1.5 years after discovery, the insurance company doesn't like the way that the discovery's going, so they invoke the appraisal process. After the appraisal process is completed, they pay the ACV minus the deductible, and a couple birds come out, and they tell the insured to go take a hike. Luckily, we've gotten past that on one of my cases, Hinojos versus State Farm, where we were kicked out of County Court Law number 6 in El Paso in that exact situation. And we said, this is not right. This doesn't make sense when the economics go completely upside down. So we took it to this Texas Supreme Court. Now, if we didn't win that, which by the way we did, insurance policies in Texas would basically be worthless. Sorry, I'm out of time.
So the first reported decision in the state of Texas on appraisal was a Texas Supreme Court case in 1886. And the language was pretty much the same as Chad said for over 100 years. And the process worked. For the next 110, 20 years, there was only 27, I believe, reported decisions talking about the appraisal process, where matters actually got disputed, ended up in courts. So appraisal worked for a really long time. But then people realized on the policyholder side that appraisal was an easy way to go get a claim paid because there's no judges, there's no ethical rules, there's no guidelines. I can go in and manipulate the process by not telling the insurance company about the process, or not telling them we're going to go get a buddy judge to appoint an umpire, or we're going to inflate the numbers so highly that the umpire just splits the baby and we make a bunch of money. So there is rank abuse of the appraisal process now. But my perspective is that it's mostly on the policyholder side, because we have people who have come into the process and realize that they can game the system for their own financial gain. The 2 fraud cases I filed were both in appraisals. One of them in litigation, All right, Chad's example about people invoking appraisal late in litigation, I agree it's wrong. If you want to go to appraisal, go before you file suit. But in the case that I had where I sued the building owner, the appraiser, and the umpire for fraud, the policyholder attorney invoked appraisal on the eve of trial. And I agree that's wrong. So we can fix appraisal if we work together to bring it back to, as Steve Patrick says, a level playing field.
The other issue to that is appraisal costs both sides money. And if the insurance company failed to perform a reasonable inspection in the first place, then why in the hell does the insured have to fork out a couple grand and pay half the cost to get a reasonable inspection done? Because that's basically what an appraisal is.
Yeah, and I would say if some PA comes in and inflates the crap out of the claim just to try to make extra money, why should my client have to pay half the cost? So the abuses on both sides drive the dialogue. I agree that's the problem. I also agree that it is cost prohibitive on smaller claims where Mrs. Smith can't afford an appraiser and an umpire. And that's why I worked with the Texas legislature a couple of times to try to come up with a statutory appraisal process where the insurance industry agrees to pay for the entire process, and the homeowner doesn't have to, in exchange for some protections to us, and the policyholder attorney bar killed it.
I disagree that it's mostly on the policyholder side. We go from two paragraphs to farmers, and I remember it was a contractor said, "Hey Chad, have you seen the new appraisal clause from farmers?" I'm like, "No." Well, and then he described it to me. I'm like, "Send me that." And sure as all get out, 14 pages. We've gone from 2 paragraphs to 14 pages, and all of a sudden, instead of the 2 appraisers agreeing on an umpire, all of a sudden the policyholder has to get or agree to, actually, they're not agreeing to anything, it's in the policy. We have a selection of umpires with the AAA, the American Arbitration Association, but don't you worry about their fee. We're going to take care of the fee. How in the world? It baffles me how insurance companies can put garbage like that in a policyholder and still say it's fair. Everybody with a brain can figure out where that's going to go, and it's going to be bad for the policyholder.
So you've just impugned the entire AAA, saying every AAA arbitrator is a fraud in favor of insurance companies, and that's just wrong.
Only those that are listed as umpires.
Yeah. And again, appraisal worked for 120 years with those 2 paragraphs. The insurance industry does not sit around wanting to change forms. They change forms in response to abuses. Look at all the new forms you're dealing with. Every single one of them is a result of an abuse. Number 1, cosmetic damage endorsements. It's because people started filing claims with tiny little dents that for 100 years nobody cared about because no one could see them. But hey, let's call it physical loss or damage. So now we have that. Same with appraisal. Same with ACV endorsements. It's all a reaction to the abuses that we're facing. I couldn't hear, I'm sorry.
Later.
Text it to Dimitri.
Russian invasion. You guys feel presidential yet? Doing good?
I feel very presidential. If I walk over and stand behind
Yes.
Steve while he answers, I think I've got the red tie on. Maybe just stare.
Are we done with the appraisal? You want to spend a little bit more time? Maybe you have questions for each other about appraisal.
Here, I've got a question for you, Chad. Do you think it's proper for a lawyer to sign up a client on a 45% contingency fee and then dump the matter in appraisal?
I don't.
Yeah. And are you aware?
Anytime I look at this from the policyholder standpoint, and if a lawyer does anything or financially sets it up that way, because I know in the instance that you're talking about, expenses are on top of that, and if there was a PA involved before that, that's not part of that contingency fee agreement either. So all of a sudden, 65% is being taken out before the policyholder even sees a dime, notwithstanding whatever the deductible was. So it's like, all right, we work it backwards. It's like, what does a policyholder need to put Humpty Dumpty back together again and make all those repairs? If you set up a situation where it will never make financial sense, like the one that you're talking about, no, I fully disagree with that arrangement.
Yeah, so let's talk about what a contractor in this room can do. If Mrs. Smith is not being paid and there's a legitimate dispute and it's as to, let's say, the cost of repair, something simple that really is subject to appraisal, what would you recommend to a contractor that they tell a lawyer or a PA as to, or let me say it differently, what they tell their client, the homeowner, building owner, is a reasonable fee to pay someone in an appraisal situation? Because I got no problem with an hourly basis or maybe 10% of the recovery to a PA or a lawyer to help facilitate appraisal. I get that. But it's these lawyers who are signing people up on a 30 to 45% contingency and dumping an appraisal that really pisses me off.
Well, it really depends on how much work would be involved, the scope of damage, number of hours, and it would be on a case-by-case basis. I know a U.S. Supreme Court justice long ago said, I can't exactly describe what porn is, but I know it when I see it. That would be a similar standpoint of if the fee for an appraisal work is too much, it's pretty obvious.
We just need to make sure the homeowner can still be made whole. That's what's important.
When does an insurance carrier owe for bad faith penalties in an insurance dispute? And he's asking if you can please act, or any one of you, please list 3 acts of brief scenarios that would qualify as a bad faith in Texas.
Yeah, well, there's different types of bad faith, as I talked about. Statutory bad faith, if we don't pay a claim timely, that is automatic. That is a sanctioned type penalty that begins to run from the date that we had sufficient information to pay the claim. So if we made a mistake and didn't pay it, even if it was a reasonable dispute, we still owe that statutory interest and attorney's fees. And that's a very broad category. Anything that we get wrong, if someone tells us we owed it, if a jury tells us we owe it, or we end up in appraisal, as Chad said, and a appraisal panel tells us we owe it, we look back to the date that we had the information to pay the claim, and we owe it. That's simple. The other type of bad faith, common law bad faith, only exists when we did not have a reasonable basis to deny the claim. That's the standard there. So those are the 2 types of bad faith. Those are the situations when we would owe those types of penalties in Texas.
How much time is needed?
The question was how much time is needed, and if you're the insurance company, that would also go along with how long is a piece of string. But since they dictate what information is needed and they dish out the questions, that's why, unfortunately, the policyholders have to put it to the insurance company, hey, do you need anything else from us? And then the question should be no, versus you run the risk of them coming back and saying, oh, well, we didn't get everything that we needed from you. Well, if you had performed a reasonable inspection in the first place, you wouldn't have to worry about that. Now, most of that is transparent. The other, as far as the reasonableness, you also have different facts. So facts and or policy language that the insurance companies use when they're sending communications to the policyholders with regarding why they either underpaid the claim or they denied the claim. The Texas Insurance Code is pretty clear. You can't use facts that aren't supported by the documentation in the claim determination. Whoever the insurance adjuster was that was out there, whatever their documentation supports, great, use that. You can't make up stuff and put it in the claim determination letter. The same way insurance companies can't just blindly copy and paste entire sections of exclusions and say, this is why we're denying your claim. I mean, State Farm actually has it on the record that that's their policy and procedure. Well, we don't just take the part that we think applies here. We take the whole section, which includes latent defect. Well, Mr. Adjuster, what latent defect did you find? Or varmint damage. Where's the pictures in your search of varmint damage? Inherent vice. You can ask the adjuster what that means. I'll tell you, 9 times out of 10 or more, they don't even know what the hell it means. But they're using it to deny claims. And they're putting it in writing. Faulty zoning, faulty planning, all have been used in claim denial letters and have nothing to do with the claim. That's bad faith. I may have gone over my time.
I'll just say one thing on this topic. We need to remember that while my client does have an obligation to conduct a reasonable investigation of the claim, the ultimate burden to establish that a covered loss has occurred is on the policyholder. Right? The policyholder has the burden to prove a covered claim during the policy period. So that is very clear. Am I right on that, Chad? Unless there's an exclusion.
After litigation starts, it certainly is.
But during the claim process, you disagree that it's not the insured's burden to prove a covered loss?
I would think that part of a reasonable investigation would be, hey, here's the damage. It's due to a storm. It's due to a pipe burst. It's due to the fire. And that's why the house isn't standing anymore. It's a pile of ashes.
I agree with that. Right? But if there is a dispute during the claim process as to whether the hail damage occurred in 2022 or whether it was in 2014, the burden on that issue is on the homeowner, and it would be reasonable for the attorney or for the insurance company to say, please provide us with whatever information you have that this hail damage occurred in 2022 and not 2014 in fulfilling the insured's burden.
I disagree. If they've already, especially if the insurance company has already made their claim determination, it's okay, we'll come back and prove that we're wrong.
The burden is on the policyholder.
The defense attorney saying, well, Judge, Chad didn't prove to us that, Chad didn't prove to us what the claim was. Well, I'm not proving it to the defense attorney, I'm proving it to a jury.
I agree at trial, but the burden is no different in the claim adjustment process. Black letter Texas law. It's just simple. So when we ask for additional information, maybe the information we have
are starting to make sense now.
The information we have shows that the hail occurred in 2014.
Why insurance companies act the way they do. I see a book.
After a drink, it looks like a real debate now. I love it. Give them more drinks, guys. All right, we have to keep moving forward. We have more agenda for today, which is more drinking for these guys, for their patience. We're going to the last sector today, manage repair programs. We're going to start with Chad. Do we have massive conflict of interest with managed repair programs? Doesn't it make insurance companies contractors? That's the question.
My answer is yes. Thank you. Thank you very much. Well, especially if it's on the policyholder to prove up that they paid their deductible up front, and if the insurance company is going to try to bring in a preferred vendor to do the work, why wouldn't they be held to the same standard? Because oftentimes they're not. But I think this goes back to two very simple concepts. One, insurance companies are profit driven, and if they're hiring a contractor to go out and perform the scope of work, there's zero likelihood that it's going to be a full scope of repair, and the quality is going to decline, period. The other is historic. Humanity has made mistakes in the past, and for whatever reason, humanity likes to erase the signs and the signals to not repeat itself. We take down statues. We've gone down this road before. It failed. Why the hell would we resurrect it? Steve?
Once again, every action has a reaction. For 100 and something years, every insurance policy has had a provision that gives the insurance company the right to repair the damage. That's under the standard valuation clause of almost every insurance company, every insurance policy. They can pay the ACV and go home, they can pay the RCV based on the cost of repair, or they can fix the damage. Insurance companies do not want to be contractors. It was seldom ever invoked. They've always had the right, but they didn't do it because they wanted to allow the building owner to choose their own contractor and fix the damage themselves. However, because the abuses have been so great, the insurance companies have said that, you know what, we'd rather set up a managed repair program or a preferred contractor program and take on the risk of becoming a contractor. I know that's the argument that's made, and put on the roofs ourselves or through these programs. In a perfect world, I would absolutely prefer to have the building owner choose their contractor. But because of the abuses, we are seeing more and more managed repair programs, preferred contractor programs coming. And I'm sorry, but if you don't like it, tell your cohorts in the industry to quit trying to screw insurance companies, all right? Because that's why it's coming.
Any answer to that, Chad?
No.
My next question is to continue on this topic. If that's the case, if insurance companies can do it, can they force homeowner to use their contractor? Because we do see that when they say, well, no, my guy is cheaper and their guy is their company. And legally, can they force homeowner to pick their, does homeowner loses freedom to pick the contractor to work with?
Yeah, so the insurance company cannot force the insured to use a contractor unless the policy gives them the right to do so. Period. That's very simple. If the policy says we have the right to repair and the insurance company invokes that right, they can choose whoever they want. That's the old scenario that never got invoked. What we're seeing now are more and more managed repair programs or preferred contractor programs where either it's required or it's optional. There's some new really progressive programs that are being put together that gives the homeowner an option to opt into a program with a select number of contractors who's been approved through a contractor-created program, not an insurance industry-created program, a contractor-created program, and then the homeowner can choose from those contractors. And I fully support that type of program.
Those are very scary words. Unless the policy says the policyholder is required to. That's really scary because the policyholder isn't the one writing the policy. The insurance company is. And as we all know, and sometimes the argument is like, well, they negotiated this contract at an arm's length distance and each one. No, that's not the way it works. The insurance company writes it up. It's written up in favor of the insurance company. And part of the problem is when you go to an agent or you go to buy insurance, you're given certain terms. The big terms, what the deductible is, how much coverage you're getting, that kind of stuff. You get basically the information that's on the deck page. You don't get the entire policy. In fact, you might not get a copy of the policy for days, weeks, sometimes months after coverage starts. So you get your policy and then you read it, as we all do, at the dinner table and discuss it with the spouse. Hey, what do we like? What do we not like? What do we have problems with? And if you did have a problem with the term, for instance, if it said that the policyholder was required to utilize these programs, you'd be like, hold it, that's a game changer, I'm out. Well, you can't just be out because you're already in a coverage period with the insurance company. So what are you gonna do? Cancel it and get a prorated premium? Now you're without insurance. You know how hard it is to get insurance if you don't currently have insurance? It's pretty hard. And the insurance companies know that. And I think that's why most of these policies are drafted in favor of the insurance company to the degree that they know that they can get away with it.
It's a contract. Parties agree to a contract, they're bound by the terms. I hope people will read their contracts.
Okay, let's finish. I have one more question, but before that, let's exchange questions you prepared for each other. One question of each for now.
One question I've got for Steve is, last time we had major changes in legislation in Texas, once in September of 2017, again in September of 2019. What's next? What can we see next that's going to be lobbied?
Two issues that I hope that we could do in Texas. Number one, I still believe, and I will continue to fight for the regulation of roofing contractors in Texas. I strongly believe, and I agree with the roofing contractor trade groups, that we need to regulate roofing contractors in Texas. That's something we should all rally behind and make happen. Number two, there is some discussion about whether appraisals should be legislated. And that is a growing dialogue because of the issues in the appraisal process. I'm not aware of any legislation that's been drafted or is prepared to be filed. But in the first party area in our space, there is no other legislative issues that are percolating right now.
Any answer to that?
No, I just wanted to know.
If I hear of anything more, I will call and tell you. But there really isn't. And I'll tell you also on appraisal. I mean, I've advocated for a statutory appraisal process for small claims because I agree. I hope homeowners can figure out a way where we can get through appraisals and help them quickly. That would be cool if we could all come together and do that.
Would small appraisals or small claims be defined anywhere?
It would be. Perhaps something, and what I wrote and shared with the Ombudsman's office at the TDI a number of sessions ago, I think it was 2015, was any claim less than $50,000. Yeah. But who knows how it would ultimately end up.
Steve, do you have a question prepared for?
I actually had two, and I was able to sneak them in during the debate on lawyers, first notice of loss lawyers, and high commissions or high contingency fees. So thanks for giving me that chance.
And like a plaintiff's attorney, I'll maintain my previous position, and I won't change it.
Do you have another question?
Nope.
Okay. All right. Then we're going to finish on this note. Last closing question. Your best advice to contractors that will help them avoid disputes with insurance companies in claims?
Yeah, that's really important to me. And every time I talk to contractors, I say the same two things. Number one, play the long game. Don't try to win the storm on every claim. All right, play the long game. There's plenty of money to be made in this business. If you are reasonable and are not trying to get rich on every claim, there's so much going on out there. Disasters keep happening. It's getting worse. So play the long game. Create a reputation that's positive on both sides. I can move a lot of business to contractors when disputes come into my office, and I refer a lot of people to reputable contractors on the other side because I know they'll be reasonable. And number two, I'll say it again, and as Chad said, I say be nice, be kind. All right, work together in the process. And if we work together, you're working cooperatively with the other side. Adjusters have no desire to extend claims. They want to get them resolved. They just need a basis to pay. Give them that basis. Lastly, sbadger@zell.com. If an issue ever comes up, send me an email, and I'll help talk it through with you and see what I can do to help you resolve the issue.
Write it down. Write it all down. At whatever time, get in the habit of keeping a journal. And when you're meeting adjusters or whomever they send out, make sure you write down the details at that time. Create the habit. And if you can't get the claim properly paid and you have to send it on, then you already have those notes to send on to the PA or the attorney. That's the biggest bit of advice I can give you. Because memories fade, and it doesn't help. I mean, it could be the most egregious confrontation on the roof that there can be, but if you don't write it down, it doesn't matter. Calling me up on the phone and saying, hey, Chad, oh man, this guy was such a jackass. I mean, the hail damage was terrible. This poor lady, there's wind damage. Great, I appreciate it, but write it down.
All right, give it up to Chad and Steve here. Thank you, guys.
Thank you, Dimitri.